Now, that Wambora ruling has once again exposed the extent of the disconnect between Parliament and the judiciary when it comes to respect for the rule of law. Now, judges are faulting the Attorney General, apparently for failing to advise the government correctly. But as Patrick Amimo reports, the AG is downplaying the supremacy battles.
High Court judges Richard Mwongo, Hilary Chemitei, Mumbi Ngugi, Christine Meoli and Helen Omondi may have stoked the supremacy wars between the judiciary and the National Assembly when they ruled that the Judicial Service Commission was not subject to the control of Parliament. The judges criticized the Attorney General for siding with the National Assembly when he quoted a section of the Powers and Privileges Act to defend Parliament's defiance of court orders.
He submits that the effect of the orders issued by the court were undue encroachment in areas reserved by the Constitution to the legislature.
The judges faulted the AG's advice to the President to establish a tribunal to investigate the 6 JSC commissioners despite court orders stopping the process.
The AG leaned strongly on the side of parliamentary supremacy.
We appreciate the somewhat awkward and untenable predicament that the AG is placed in by this petition. We have a new constitution that has brought an earth-shaking change in our governance structures. The AG must find the middle ground that enables him to play his constitutional role as the principal legal advisor of the government.
While officially launching the Kenya Law Reform Commission, the AG may have been alive to the criticism from judiciary but seemed to play down the supremacy wars.
Notwithstanding occasional misunderstandings between the various arms of government, as we settle into our constitutional mandates, we are one government.
The Senate Speaker Ekwe Ethuro said conflict resolution will be one of the Commission's key challenges as it interprets the law on separation of powers.
Last 1 year of devolution has been awash with the disagreements between the two houses of Parliament, between the national government and the county governments. And I think it is important that when we invest in institutions, they will be able to help us in some of these things.
Parliament and executive have been at loggerheads in the past as each sought to control its staff.
Let us not frustrate one another. You have a role as Parliament to hold us to account. We accept.
The executive is watching, and the people to oversight the executive, it is us.
Interestingly, the executive and Parliament have occasionally ganged up to attack the judiciary when their common interests converge.
The legislative authority of the Republic of Kenya vests exclusively in the legislature, in Parliament.
Majaji wote waheshimu kazi yao na watuheshimu. Otherwise tutaibishana bure.
The one government whose objective is to serve 40 million Kenyans. One arm should not prevent another from doing its business.
The standoff among the three arms of government seems to have been complicated by provisions of the new constitution, which was largely aimed at checking the control by the executive over the other two arms. Patrick Amimo, KTN.